This is the Employers Consultative Association's The Voice of the Employer, sponsored by Royal Castle. Our culture, our taste.
Stop hunting up and down for food, barely in a hungry mood. Royal Castle's home flavor, taste of culture. Chicken, coleslaw, fries, everything bursting with we own seasoning. Royal Castle's local treat, you crave to eat. We rotisserie veg and fish is boss, tempting tasty pepper sauce. Royal Castle's home flavor, taste of culture. Royal Castle's home flavor, the taste of our culture. Royal Castle's home flavor, the taste of our culture.
Good morning, listeners. I am Shelley McLean Robinson, HR Administrator at the ECA. This week, I wish to provide a brief perspective on varying an employment contract. Working relationships change for many reasons, some of which exist outside the control of the employer. When this occurs, employers are forced to consider making changes to their employees' contractual terms and conditions of work. While this is possible to achieve, varying such terms without having a contractual right or without going through the proper procedures can create exposure to risks associated with costly claims for breach of contract, constructive dismissal, strained employee relations, and a negative public image. An existing employment contract can only be varied with active consent and agreement, preferably in writing by both parties. This can be on an individual basis or through a collective agreement in the case of unionized employees. Subject to existing agreed terms and conditions of employment, an employer who is desirous of changing particular terms of his employee's contract of employment must adequately consult with impacted employees and, as applicable, their representative, clearly outlining the reasons for the proposed changes. In general, unless proposed changes will significantly diminish existing terms and conditions, employees tend to be much more receptive to contract changes if given an opportunity to understand the underlying reasons and to express their views. Involving employees in the change process can go a long way in improving motivation and engagement levels and more likely result in successful negotiation of the proposed changes. Where a variation to the terms and conditions of a contract has been agreed upon between both parties to the contract, employers should ensure there is also agreement on the implementation date and, as practicable, give written notification of at least 1 month or earlier to the changes to be effected. In certain cases, a contract may contain expressed terms which allow an employer to make changes to contractual terms and conditions. While this flexibility clause can be general or specific, employers should note that courts often place a fairly narrow interpretation on flexibility clauses. It is therefore advisable to seek professional advice before including or executing such a clause in an employee's contract of employment. If you are unable to reach an agreement with your employees, employers can serve notice to terminate the existing contract and offer the employees re-engagement on the new terms. This option should be considered only after full and thorough consultation with employees and their representatives, and treated as a last resort upon professional advice. By implementing this option, you will be terminating the services of the employees, and it is therefore important that you follow a fair and just process. Varying contractual terms is a complex matter. It is therefore advisable to seek independent advice from the ECA before embarking on such an exercise. Should you require further information, kindly contact us at 675-9388. Visit our website at www.ecatt.org or follow us on Facebook, LinkedIn, or Twitter. Do have a productive and rewarding day.
This has been the Employers Consultative Association's The Voice of the Employer, sponsored by Royal Castle. Our culture, our taste.